The respondent refuses to cross-examine me until I file my affidavit of assets and liabilities. There was a claim for alimony which I have withdrawn.
Throughout the petition, they have always suppressed the facts. And when the time has come where it has to be disclosed, they are trying to, in the guise of setting the FC order, interim stay, they are attempting to set aside the order which was passed by this very court.
Lord, the reason is this. She has purchased, my lord, some properties which we will have to disclose in the AOD. The only reason she does not want to disclose is because there is going to be, my lord, some embarrassment cost to her. There is no claim I'm making for any further monetary support from the father at all. Not for myself, not for the child.
No, but I've already paid about 6,50,000 over the years, Your Honor. If my defense was struck off.
Your client is not being fair to the and why she is doing all this. Your party is afraid of filing the statement of assets and liabilities because somewhere like she must be thinking that it will be adverse to her statements or made earlier.
I cannot be invited, my lord, to give evidence against myself.
Yes.
Yesterday's matter, the respondent wanted to make submission.
Are you appearing as a party in person?
Yes, Your Honor. I'm filing a memo.
You appeared before the committee?
Not yet, Your Honor. The copy was also served through a WhatsApp, Your Honor. I don't have the physical copy. I requested so many times.
Requested who?
All the junior counterparts in the family court. I've sent a message.
What is any urgency in this
But
matter?
the urgency is this. Your lordship has directed the family to 2015 matter, my petition for divorce. There was a stay order passed by the Honorable Court, not of further proceedings. And then your lordship passed an order at page number 46, operative portion, directing the family court, my lord, to dispose the main matter before the 15th of December. Page 51, my lord, is the time limit has been fixed. It is for my cross-examination. The respondent refuses to cross-examine me until I file my affidavit of assets and liabilities. There is no monetary claim pending before the family court at all. There was a claim for alimony which I have withdrawn. Cross-examination is not, he's not proceeding with until I comply with your lordship's order, my lord, at page number 51, directing both parties to file the statement of assets and liabilities at page 51. That was at a time when my claim for permanent alimony was pending before the family court.
No. This order, what was the impugned order in this writ petition?
The father had challenged the order of maintenance, interim maintenance granted to the child. 10,000 rupees was awarded to the child as interim maintenance.
He is paying still.
He's been paying 7,500.
And then why not this is necessary if it is he's claimed that you're earning. So if you don't file your statement of assets and liabilities, when there is a direction by this court, you ought to have filed. And if you don't file, if you want any modification, you should have approached the court. And you just can't keep quiet saying that no, I have I don't have any other claim on monetary aspects, so I will not file. That can't be the.
Your lordships have specified in the
Both
order.
the parties shall file their respective statement of assets within 15 days from the date of receipt.
Kindly see direction number 4, my lord.
Yes.
As per the interim order, the petitioner husband shall continue to pay the maintenance per month to the respondent wife till disposal of the MC. MC has to be disposed of by 15th of December.
Because now the court will consider why this arrangement is made. Again, making adjudicating on the interlocutory stage or on the maintenance, this will be adjudicated finally.
I'm not making any claim at all.
No, for 7th, what about the maintenance to the child?
I'm not claiming, my lord. After your lordship's order, my lord, spends itself by 15th of December, there is no claim I'm making for any further monetary support from the father at all. Not for myself, not for the child. Not the entire exercise.
In the pendency of the matter, why should he pay?
For 2 months, your lordships have directed him to pay. The matter was disposed of. My lord,
it appears to be that something is not.
So the reason is this.
No, the reason is she has already, whatever she has stated.
Yes.
Maybe not right that she doesn't want to place things on record.
Lord, the reason is this. On the last occasion, there was a visitation order passed by the family court in an execution proceeding where the father came near her house and created ruckus. She has purchased, my lord, some properties which we will have to disclose in the AOD. The only reason she does not want to disclose is because there is going to be, my lord, some embarrassment cost to her, humiliation cost to her. Therefore, she's even giving up claim for. I've been appearing in this matter, my lord, from 2018 before the family court. So I'm aware of, my lord, what transpired in the execution proceedings. A child has in fact been referred to NIMHANS for counselling by the division bench in an appeal filed by the mother against in the custody proceedings. These are the issues, my lord, that are pending.
No, she doesn't want permanent alimony. She doesn't want maintenance. Even the maintenance that you are paying, you don't pay to her. So why the statement of assets and liabilities are necessary? at this juncture?
Your Honor, the maintenance was awarded by the principal judge without the assets and liabilities. So there's a lot of
No, they
confusion.
don't want.
No, but I've already paid about 6,50,000 over the years, Your Honor. My defense was struck off on this matter. And in fact, they're trying to, in the guise of setting the.
Governor,
family
what will
court
happen to his amount that is
The
paid?
order that was passed was prior to Rajneesh and Neha. 2018 was the first order of maintenance, at which time there was no requirement for either parties to file their affidavits. And the second order was passed on 9/9/2019, prior to Rajneesh and Neha. So it is not a question of me not complying with the requirement of the law and therefore having to file this affidavit of assets and liabilities.
For how much is she sought?
Initially, I sought 75,000 rupees both for myself and my child. 25,000 rupees was awarded by the family court. That was challenged by the father. It was reduced to 10,000 rupees and the matter was remanded back to the family court for fresh consideration. Family court has passed an order in 2019 awarding 10,000 rupees per month, which was further reduced to 7,500, only for the child, not for me.
Your Honor, so throughout the petition, they have always suppressed the facts. And when the time has come where it has to be disclosed, they're trying to, in the guise of setting the FC order, interim stay, they're attempting to set aside the order which was passed by this very court, Your Honor.
No, they do not want, she doesn't want alimony. Now, no further maintenance they want for the child. In that case, what is, if the statement of assets and liabilities are not filed, what is the impact of it on your case?
Your Honor, this will lead to clear suppression of the facts. And I think the counsel is already aware there's a perjury and contempt application which is pending before the MMTC court. So they don't want to commit.
What is that application?
It was about cruelty, Your Honor. That's already been dismissed and they've gone on a criminal
No,
appeal.
perjury application, what is it?
Which-
Perjury application on what ground?
On not disclosing the facts, Your Honor.
Of what?
In the assets and liabilities, they have lied quite a lot, Your Honor. So
Where did they file?
in MMTC 5, Your Honor.
They have already filed.
Yes, Your Honor. And again, they have gone for a criminal appeal, Your Honor. And there also the matter is pending. So they want to avoid a double perjury and they are avoiding to file the assets, Your Honor. So clear suppression of facts, Your Honor. And they even sought the strike off of the defense on this matter. I had to approach the Honorable High Court several times. And when the time has come to correct it, they are avoiding filing.
Where is that strike of the defense?
In this very court.
Your Lordship's order, my Lord, there were two orders. One was challenging the direction to pay maintenance of 10,000 rupees, and another was where the family could have struck off his defense for not paying the maintenance. Both writ petitions were clubbed together. There's a common order passed by Your Lordship in both the writ petitions. This is all in 2019, much prior to Rajneesh and Neha. May I make this submission, my Lord? Kindly see the attitude of the respondent. The only reason he wants me to file my affidavit of assets and liabilities is because now the matter is posted for cross-examination. Cross-examination on my assets and liabilities statement can go on, which he wants to use for the other case, where he says there is some perjury application that is filed. There is no prejudice caused to him because I'm not making any claim before the family
Your
court.
client is not being fair and why she is doing all this.
No, there has been
No,
a
whether
history.
because he has every right, because
There's a history to the relationship.
he is litigating, either he can have this or that, like, nothing wrong with that.
True, my Lord.
But your client has to be fair to the.
But I'm not making any claim. The requirement to file the statement of assets and liabilities is only if there's a
You filed
monetary.
a statement of assets and liabilities before the other court.
In 7 years ago, in 2018, or not in 2018, sorry, I'm from 2020. I'm not appearing in that matter. The domestic violence, somebody else is appearing. But that was from the instructions that was more than 4 or 5 years ago.
No, Your Honor.
Not-
The
But
file is
did
very
you
recent.
seek for, no, one more thing is,
Yes.
an order is passed,
Yes.
directing the court to dispose of the matter, and in that one of the clauses that you have to file your statement of assets and liabilities.
But ultimately, my Lord, the object of serving filing the statement of assets and
It's
liabilities
true,
is
that I
only
can
if there's a monetary
understand,
claim.
that I can understand.
Yes.
But at the same time, your party is afraid of filing the statement of assets and liabilities because somewhere like she must be thinking that, it will be adverse to her statements or that are made earlier.
I cannot be invited, my Lord, with great respect, to give evidence against myself.
तलाक, एलिमनी और इंटरिम मेंटेनेंस के मामलों में क्या पति पत्नी दोनों के एसेट्स और लाइबिलिटीज दाखिल करना जरूरी होना चाहिए? क्या इससे कोर्ट को सच तक पहुंचना आसान होता है? नीचे कमेंट्स में अपनी राय जरूर दीजिए। कर्नाटक हाई कोर्ट में आज ऐसा ही मामला सुनवाई में आया, जहां पति खुद अदालत में पेश होकर न्याय की मांग कर रहे थे। उनका कहना है कि वह कई महीनों से मेंटेनेंस दे रहे हैं और अब तक करीब 6 लाख रुपए चुका चुके हैं। उनकी सिर्फ एक मांग है, पत्नी अपने एसेट्स और लाइबिलिटीज कोर्ट में दाखिल करे ताकि वह उस पर क्रॉस एग्जामिनेशन कर सके। वहीं दूसरी ओर पत्नी का पक्ष कह रहा है कि अब उन्हें कोई पैसा नहीं चाहिए, न मेंटेनेंस न एलिमनी, इसलिए वे अपने फाइनेंशियल डॉक्यूमेंट्स दाखिल करने को तैयार नहीं है। पति का दावा है कि अब सच सामने आएगा क्योंकि उनकी पत्नी ने कोर्ट में झूठ बोला है और परजुरी की है, इसलिए वे इन दस्तावेजों से बच रही है। पत्नी की ओर से वकील ने कहा कि पति ये डॉक्यूमेंट्स इसलिए मांग रहे हैं ताकि इन्हें दूसरे मामलों में उनके खिलाफ इस्तेमाल किया जा सके और हाल ही में पति ने कुछ संपत्तियां भी खरीदी हैं, इसलिए ये दस्तावेज दाखिल करना उनके लिए खतरनाक हो सकता है। इस मामले का अगला हिस्सा जल्द ही आपको अपडेट करेंगे। फिलहाल के लिए बस इतना ही। धन्यवाद।